everybody. It's Rob Seaver, Executive Director with Leeds Counsel. I'm excited to bring you the second in almost as many weeks. We've had a new Supreme Court ruling today. I want to get down to the down and dirty of this. I've invited those special guests. You know them. I've had them on before. This is the czar of TCPAworld.com, partner at Squire Patton Boggs, Eric Troutman. Thank you for joining. I'm also joined by his fellow partner, principal over at Squire Patton Boggs, Daniel Delnero. Please give us a round of applause. I've got to give you something like this, guys. Thank you for joining me today. This is exciting. Eric, real quickly, let us know what happened today. I read your post. It's something that triggered me immediately. Got you on this call. What are we looking at?
No, I love the U.S. Supreme Court. I'm going to say it. Sometimes they make me a little grumpy, but they've given us 2 rulings here in the last month that stand for something really meaningful for all of us. It stands for this thing, right? Constitution of the United States, and I love to see it. So back in Facebook, you remember the Supreme Court kind of reined in the expansive definition of the TCPA that the FCC, remember, invented for itself. Huge power grab back in 2003 when the FCC expanded its own mandate, took over essentially all of robocalls by interpreting the TCPA very broadly to give itself more power. The FTC was doing the same thing under Section 13 of the FTC Act. It gave itself more power to go off and get some additional remedies that Congress did not give it. The FTC just decided for itself. It was entitled in these preliminary proceedings to go off and get damages because, in its view, these people were plainly wrongdoers and they had gotten a bunch of money and the FTC was going to go get it. And the courts were letting them get away with this. The statute did not give them that power, but the courts were letting the FTC use that power. And the Supreme Court 9-0 today said, damn the consequences. FTC, you are not allowed to do this. The statute does not give you that power. How dare you use that power? Courts, how dare you support the use of that power? This is all illegal. None of it was ever permissible, and it's done. You're not doing it anymore. And yes, this is a ruling essentially in favor of bad guys. But at the end of the day, the Supreme Court says upholding this thing, the Constitution, and making sure that agencies don't invent power for themselves is more important. And I love to see it. I love it.
Okay, so help me understand this, because quite honestly, this is a bit confusing, because I've also talked to your partner prior to you logging on about, does this mean that the FTC no longer can go after people for money, or do they have to go about it a different way? Or help me understand a little bit about that.
You got it right. So the FTC has power still to go after people and get money where people commit fraud or they violate the FTC Act, but they have to work hard to do it, right? They actually have to do their job, and I'm saying this with love, but they actually have to establish, right, all of the different components and elements of a claim. What they were doing before under Section 13 was they were kind of going into court and on a preliminary basis making a very kind of prima facie showing and getting orders to get money back. They're not allowed to do that anymore. Instead, they're going to have to fall back on the traditional process of the civil investigative demand, the CID, and actually do their work. Probably going to assign more resources to this now, which means CIDs, as Daniel's about to tell you, are even more important than they've ever been. And this actually explains, right? We've seen a glut, have we not, Rob, of new CIDs coming out from the agency. It's almost as if they knew this was coming. It's almost as if the FTC understood that these preliminary remedies that they've been using for themselves were not going to pass muster. The Supreme Court was not going to allow it, and they've already laid the groundwork for additional enforcement under FTC Act 5 by using CIDs, which they've already issued. It all comes full circle. Everything is starting to make a lot more sense.
So Daniel, he teed you up, but give me one more second because I have one more question for the czar. What does this mean for companies that may currently be going through CIDs? Anything, business as usual? Can they just toss out their current attorneys and handle it by themselves in court? What do you say about that? I know you love the crystal ball.
Yeah, no, CIDs are more important than they've ever been. The CID process now is the only effective and true process by which the FTC can gather the evidence it needs to pursue the remedies under FTC Act 5, which include, of course, suing you, using the information that you provide and using it against you and suing you, right? That's what the CID essentially is all about to begin with. So remember, the FTC still has power. It just has to now prove its case. Whereas before, it was essentially not having to prove its case using the CID, at least not to the full extent that it has to now.
And we still have the CFPB out there on the financial side that can issue the CIDs as well and go after you financially as well. Am I correct about that, right? This didn't impact that at all.
That's correct. The CFPB and all the other agencies now, this is a shot across everybody's bow, right? Any other agency that was thinking it was going to kind of expansively interpret its grant of authority is now put on notice. Everybody is put on notice. The Supreme Court is not going to put up with it. And if you are now a district court judge anywhere in this nation, you're going to look up at this ruling and you're going to say, okay, if Congress has given the agency the power to do something, I'm going to enforce it. If the agency is giving itself a power to do something that Congress didn't allow, I'm not going to enforce it anymore. That's what the Supreme Court did.
What happens to a penalty 4 years ago when they did it through the way that was just thrown out?
Daniel, why don't you answer that? I'm curious.
Okay, Daniel. Well, look, Daniel, he teed you up like 18 times. I saw you chomping at the bits over there. I want to announce that July 22nd, 23rd, we're putting on a 2-day workshop. We've got a lot of things still to work on, but I'm working with Daniel. I'm working with Eric here to put together the content. And it was really something when I heard this news today that concerned me, because I was like, oh, maybe CIDs don't matter anymore. And, as soon as I called you, Daniel, and you talked to me, you were like, no, actually, this might be the best time for this workshop to be put on. And so follow up from what Eric said, and then help us roll into, why you said that about the workshop as well.
Sure. So really, the FTC has two avenues. By the way, the same contact that was illegal under the FTC Act yesterday is still illegal under the Act today. This ruling only deals with the enforcement mechanisms. There are two large enforcement mechanisms within the FTC Act. One is the ALJ process through Section 5 and Section 19. The other is the process where you can go straight into court, and that was under Section 13B. 13B allowed the FTC to go straight into court so that to get preliminary and then permanent injunctive relief and bypass the administrative law process. Well, starting in the 1970s in the antitrust area, but then really within the last 15 years on the consumer protection side, the FTC started abusing that power and was using its 13B right to go into court to get permanent injunctive relief, to get actual monetary damages. They were categorizing it as injunctive relief, but it wasn't. It was pure monetary damages. And really, the problem with that was it bypassed all the administrative rights that companies subject to FTC jurisdiction had. So instead of first being an ALJ hearing and then having an opportunity to appeal the ALJ determination to the commission, and then having the opportunity to challenge that determination in court, the agency could go direct to district court in summary fashion and get an injunction for past consumer harm. It made no sense. It was abuse of power, but district and circuit courts were allowing it. That is cut off. Now they have to go through the investigative process to get monetary damages. They have to go through the investigative process. They have to have an ALJ hearing, and then only then, after there's an ALJ determination that a violation occurred, can they go into court and get monetary damages. It's the way the Act's written. It's the way everything should have worked. They can't bypass it. So what's the impact? What's the on-the-ground impact? One, you're going to see the summary proceedings are largely going to be out the window. They're only going to be used to stop active wrongdoing, not to remedy past behavior. So what's going to happen when the Bureau wants restitution? What's going to happen when the commission wants to redress consumer wrong? It has to actually go through the CID process, bring an enforcement action within the admin agency, and then let that work its way into court. So it will be a longer drawn out process, which means I would suspect, and we're seeing this, the CIDs will become more robust, and they will likely drag on a bit longer because they have to go through the ALJ process anyways. And the more difficult the Bureau can make going through a CID, the more they can coerce an early consent agreement, because that's their real aim when they do that. Additionally, if the Bureau is really, truly worried about imminent wrongdoing, imminent consumer harm, there's a chance that they might start start referring matters to the DOJ earlier. The FTC and other agencies can refer an investigation to the DOJ for civil or criminal action. If they think that there's real wrongdoing that rises to the level of a criminal RICO or criminal mail-in wire fraud, this might make it a bit more likely that they'll do an early DOJ referral, which makes getting in really experienced investigatory counsel as soon as you get that CID even more important, because you could be looking at criminal referrals now, whereas in cases where they previously would have just gone after a quick monetary injunction.
So, I mean, using our Vegas reference for July, the price of poker looks like it just really did go up. So I may be wrong about this, but, I know, Eric, both you and Daniel said earlier, this only makes today's ruling and what we're doing at the council with our self-regulating organization advancements that we're doing, the education, the advocacy, the lobbying that we were prepared to do. This industry needs to pay attention to today's ruling, needs not to take advantage of recent rulings to start doing bad actions. It actually could be a little bit more difficult for you to stay out of the eyes of these, and maybe that is a good thing for consumers, but we'll see how this all rolls out. Is there anything else that either one of you would like to add before we wrap up?
Yeah, let's give two pieces real quick. One, Congress is going to look at this, okay? And I'm fine with that, right? I don't take a position ultimately as to whether or not the FTC should be granted this power by Congress. My point, and the Supreme Court's point, is until the FTC is given this power, it doesn't have it, right? And that is what the Supreme Court ruled today. It's a very simple doctrine. The logic here is infallible. And obviously I'm supportive of that. Now, if you want to talk to Congress about that, you need to lobby, because the Congress has already issued a hearing today. It's on tcpaworld.com if you want to watch the hearing. So this thing is rolling very quickly. Remember, the TCPA told all of you, don't expect quick congressional action. I was right. The Congress is going to move very quickly. So if you want to be heard, you got to do it right now. Secondly, people are going to have questions. What if you've been hit with one of these summary monetary penalties in the past? Can you unwind it? Answer is maybe, right? If this action was per se unauthorized, then these orders are arguably void. Now, there's a lot baked into that. A lot of analysis is necessary. So that is something that you ought to think about and maybe retain counsel to look into. But moving forward, as Daniel was saying, you're not going to see this anymore. What are you going to see? You're going to see full-bore CIDs. You might see ALJ actions, as Daniel was saying, but he used the three-letter acronym you should all be most afraid of, which is DOJ, right? That's where these things in all likelihood are going to be heading as a stopgap maneuver. But the CID, again, that process, expect more resources from the commission, at least in the short term, focused on those as the other enforcement avenue dries up. Daniel, any last thoughts?
Yeah, I agree with what Eric said, and it's very important to get out in front of a CID early. Don't just blindly turn over documents. Make sure you're asserting all relevant privileges. Make sure you have counsel who is familiar with both civil and criminal enforcement mechanisms, because frankly, you're going to need both. And when you get those things, take them seriously, because the commission is, and the CFPB is, and you have very, very aggressive regulators in both, and you have lower line level enforcement attorneys who had their hands tied for the last 4 years, who now they've just been cut loose by this administration. So there's pent up demand on their part for actions they would have liked to have taken over the past 4 years, that now they're going to have more freedom to do so.
We're already seeing it. So, I mean, we know that that's a fact. Eric, Daniel, thank you guys. I know that this is a busy day for you. Carving out time for the council is important. Once again, save the date, July 22nd, 23rd, Caesars, Las Vegas. We're going to learn about this and more. You can't miss it, especially if you're in regulatory or compliance for your company. So, Eric, Daniel, thank you again. Can't thank you enough.
See you folks in Vegas.